exactly time, so we will get going at this point. And I want to thank you for attending the United States Sentencing Commission's second public meeting of the year. We appreciate the attendance of those joining us here today, some familiar faces, as well as those watching through our live stream broadcast on the Commission's website. Once again, I appreciate the strong interest in sentencing issues and the work of the Commission. The first order of business is to adopt the January 8th, 2016 public meeting minutes. Is there a motion to do so?
I so move.
Is there a second?
Second.
Any discussion? All in favor?
Aye.
Any nays? The motion's adopted by voice vote. The next item of business is my report as chair, and I'd like to update you on a few important developments. The Commission unanimously voted to adopt an amendment relating to the definition of crime of violence in the career offender and other federal sentencing guidelines in January. The effective date for this amendment is August 1st, and the Commission will publish a supplement to our guidelines manual that incorporates the new amendment at that time. The January amendment is not our final work related to this area of crime of violence. We are working on a report to Congress on career offenders and other recidivist provisions later this year, which may include recommended statutory changes. Also, the Commission is currently accepting written public comment on proposed revisions to the Commission's rules of practice and procedure. Please note, if you are interested, written public comment on these changes should be submitted by June 1st, 2016. That's June 1st, 2016. The proposed changes can be found at the Commission's website at www.ussc.gov. Instructions on the submission of public comment are on the website, and we're very, very modern now, as well as a link to the sign-up on our Twitter and email alerts. Briefly, I'd like to highlight a few of the Commission's recent research projects and publications. A few weeks ago, the Commission released its first in a series of publications on its multi-year recidivism study. The study is groundbreaking in both its breadth and in its duration, analyzing recidivism in multiple ways, including rearrest, reconviction, and/or reincarceration. A few takeaways are key findings. Nearly one-half, that is 49.3%, of the federal offenders studied were rearrested within 8 years of release for either a new crime or for some other violation of the conditions of their probation or release. So almost one-third, 31.7%, were reconvicted, and one-quarter were reincarcerated. Second takeaway, the guidelines criminal history score remains a very good predictor of future recidivism. Age, offense type, and educational level were also associated with future recidivism. In addition, with the exception of very short sentences, that is sentences less than 6 months, the rate of recidivism varies very little by length of prison sentence imposed. Again, these are just a few findings of a recidivism report. Please read it, and there's more to come in future months. Recently, the Commission published its fiscal year 2015 annual report and source book. And perhaps the most interesting trend is that the federal criminal caseload continues to shrink. In past years, the decreased caseload was largely driven by declining immigration cases. But this year, the decreases were more evenly distributed across the major offense types. Regarding sentencing training, last September we had approximately 1,000 judges, probation officers, and practitioners attend our national training seminar in New Orleans. This year, the seminar will be held in Minneapolis on September 7th to the 9th. Please look for the registration information on our website in the weeks ahead. So as always, there's a great deal of work going on here at the Commission, and I wanted to provide you with a few activities before we turn to the business before us. As we ordinarily do in April, we're now back in our ordinary cycle. We will now vote on whether to adopt the pending amendments to the federal sentencing guidelines. So the next item of business is possible votes to promulgate proposed amendments, and I will turn it over to the General Counsel. Ms. Grilly.
The first amendment before you for your consideration is the Miscellaneous Amendment, which is a multi-part amendment responding to recently enacted legislation and miscellaneous guideline application issues. Part A of the proposed amendment responds to the USA Freedom Act of 2015 and addresses new offenses created by the Act by referencing them in Appendix A to various Chapter 2 guidelines and making appropriate clerical changes to the guidelines. Part B of the proposed amendment amends Appendix A to reference offenses under Section 1715 to 2K 2.1 and establishes a base offense level of 6 for such offenses. And Part C of the proposed amendment amends the background commentary to 2T 6.1 and makes corresponding changes to the introductory commentary to Chapter 2, Part T, and in the background commentary to Guidelines 2T 2.1 and 2T 2.2. A motion to promulgate the proposed amendment with an effective date of November 1st, 2016, and with technical and conforming amendment authority to staff is appropriate at this time.
Is there a motion?
So moved.
Is there a second?
Second.
Any discussion? All in favor?
Aye.
Any nays? The motion is adopted, and let the record reflect that at least 4 commissioners voted in favor of the motion.
Yes, the next amendment for your consideration is a proposed amendment on compassionate release, which is a result of the Commission's work in reviewing the policy statement at 1B113. First, the proposed amendment revises the Commission's guidance on what should be considered extraordinary and compelling reasons for compassionate release. It provides 4 broad categories: medical condition of the defendant, age of the defendant, family circumstances, and other reasons. Second, the proposed amendment amends the commentary in 1B113 to provide that an extraordinary and compelling reason need not have been foreseen at the time of sentencing in order to warrant a reduction. Third, the proposed amendment adds a new application note encouraging the director of the BOP to file a motion if the defendant meets any of the circumstances listed. And finally, the proposed amendment adds a reference to the Commission's general policy-making authority under 28 U.S.C. 994A2 to the background commentary. A motion to promulgate the proposed amendment with an effective date of November 1st, 2016, and with technical and conforming amendment authority to staff is appropriate at this time.
Is there a motion?
So moved.
Is there a second?
Second.
All right, is there any discussion on it?
I was going to say something. I just want to say a brief word about compassionate release. The Department of Justice told us, and I believe might remind us again today, that what we should do is adopt our criteria for compassionate release to be equivalent to what the Bureau of Prisons has. And they have emphasized to us that no one gets compassionate release without a BOP motion, signifying that BOP is the gatekeeper to this process. And what I want to emphasize is that Congress did not give the BOP the authority to run this program entirely on its own. It charged the Commission with describing in general policy statements what should be considered extraordinary and compelling reasons for a sentence reduction under 28 U.S.C. 994T. So while we take BOP's views seriously, we nevertheless have an independent responsibility to set out the criteria. Where we made changes from BOP's statements, we did so based on significant evidence. For example, whereas the BOP guideline insists that a terminal illness be considered only when it's accompanied by a life expectancy of 18 months or less, our record shows that this requirement doesn't comport with medical practice, which instead emphasizes an end-of-life trajectory. So our proposed amendment removes the 18-month requirement and instead reflects what we've learned from medical research. In this regard, I would just like to express our gratitude for the testimony and assistance of Dr. Bree Williams. In our proposal, we give specific examples of the kinds of serious and advanced illnesses with an end-of-life trajectory that are covered, including ALS, end-stage organ disease, and metastatic solid tumor cancer. We've also made clear that compassionate release is available to inmates who are 65 and older, experiencing seriously deteriorating health, and who receive sentences of less than 10 years. Under BOP's current policy, an individual must serve at least 10 years to be considered, which has the perverse effect of extending this option to those who commit more serious offenses, but not to those who commit less serious offenses who may be suffering from equally serious deteriorating health. We make clear that you don't have to have a sentence of at least 10 years. You are also eligible if you serve at least 75% of your sentence, whichever is less, to make clear that compassion is not reserved for only those who commit crimes that yield longer sentences. I personally would have extended this further to reach individuals as young as 60 based on our recidivism data and Dr. Williams' testimony about the effects of prison on aging. But I think the amendment you have before you, for us, that reaches to 65 is amply supported by the record. We also state in this proposed amendment that we encourage BOP to file motions when individuals meet these criteria. That's because that is all the statute allows us to do, to encourage. I wish we could do more, because we have a record filled with heartbreaking cases of individuals dying in prison and their families and friends shut out from spending their final days with them because of the BOP process that is broken, and that's well documented by the Department of Justice's Inspector General and our own record. This is not just a question of compassion, but public safety and the rational deployment of limited resources. Inmates over 50 are the fastest growing segment of BOP, and the IG found that BOP spends about a fifth of its budget on aging inmates, who are most costly because of their medical needs. The Inspector General found that BOP lacks specific programming to meet the needs of this population and has a woefully inadequate number of social workers to address their needs. There are 36 for the entire BOP. This population also has dramatically lower recidivism rates. So releasing these individuals frees up space in overcrowded prisons, and the resources we save could be better spent on more significant law enforcement needs. So I hope we can work with BOP to get more of these motions filed in court, because I believe it is in the interest of all of us to do so. Thank you.
Thank you. Did you?
I have a brief comment about that, but I'd rather do it all in the summary statement at the end.
Fun. Okay, that's great. Well, as the Commission prepares to vote on changes to its policy statement on compassionate release, I want to thank everyone who testified at our hearing in February or submitted public comment, including representatives from the Criminal Law Committee, the Department of Justice, the Bureau of Prisons, the Inspector General, the Federal Public Defenders, the Practitioners Advisory Group, again, Dr. Bree Williams, the ACLU, FAM, and NACDL, among others. I'm always reluctant to list everyone because if I've forgotten someone, I'm sorry. The whole hearing was terrific. Congress charged the Commission with issuing policy statements describing what should be considered extraordinary and compelling reasons for a sentence reduction. With the vote on this proposed amendment, the Commission is exercising its authority in this area by broadening the criteria beyond that in the Commission's current policy statement and the Bureau of Prisons program statement. The revised policy statement also encourages the Director of the Bureau of Prisons to file a motion for sentence reduction if the defendant meets any of the circumstances set forth in the Commission's policy statement. While the Bureau of Prisons testified that the agency is trying to expedite consideration of compassionate release requests, we are concerned that so few have been granted. The BOP, Bureau of Prisons, reported that between August 2013 and December 2015, the BOP received 3,142 compassionate release requests based on medical or age-related reasons. During the same period, BOP approved 261 for medical or age-related reasons. Of those, 68.2% were for terminally ill offenders. We hope that these revisions prove to be a constructive step in addressing some of the concerns we heard, both in public comment and at the public hearing, regarding eligibility for compassionate release for the elderly, the terminally ill, and prisoners with other extraordinary and compelling circumstances. So we will have a vote on the motion. All in favor?
Aye.
Anyone opposed? The motion carries, and let the record reflect that it was unanimous. Now, moving on to the next issue.
Yes, Judge, thank you. The next amendment for your consideration relates to conditions of probation and supervised release. This proposed amendment revises, clarifies, and rearranges the conditions of probation and supervised release, and is a result of the Commission's multi-year review of federal sentencing practices relating to the conditions of supervision. It is also informed by a series of opinions issued by the Seventh Circuit in recent years. In general, the changes in the proposed amendment are intended to make the conditions of supervision found in 5B 1.3 and 5D 1.3 easier for defendants to understand and for probation officers to enforce. A motion to promulgate the proposed amendment with an effective date of November 1st, 2016, and technical and conforming amendment authority to staff is appropriate at this time.
Thank you. Is there a motion?
So move.
Second?
Second.
Any discussion? Anyone make any comments? I do. Before, I want to briefly discuss the proposed amendment to Chapter 5 of the Guidelines Manual, which concerns conditions of probation and supervised release. Based on a series of circuit court decisions criticizing several standard and special conditions of supervision over the past 2 years, both the Commission and the Criminal Law Committee review the conditions of supervision that appear both in the Guidelines Manual and also in the judgment form used by the Administrative Office of the U.S. Courts. Over the past year, our staff worked closely with the Criminal Law Committee staff to obtain helpful input from all of the stakeholders in the federal criminal justice system. From this process, the pending amendment seeks to revise many of the so-called standard and commonly imposed special conditions. One goal is to make sure that the conditions are not imposed woodenly and instead are designed to reflect the individual characteristics of each offender. All in favor?
Aye.
Aye.
Anyone opposed? Okay. So, the next issue.
Yes, the next amendment for your consideration is the Animal Fighting Amendment, which revises 2E 3.1 to provide higher penalties for animal fighting offenses and respond to 2 new offenses relating to attending an animal fighting venture. The proposed amendment revises 2E 3.1 to provide a base offense level of 16 if the offense involved an animal fighting venture. It establishes a base offense level of 10 in 2E 3.1 if the defendant was convicted of causing an individual under 16 to attend an animal fighting venture, and a base offense level of 6 in 2X 5.2 for attending an animal fighting venture. Finally, the proposed amendment revises the existing upward departure provision in that guideline. A motion to promulgate the proposed amendment with an effective date of November 1st, 2016, and technical and conforming amendment authority to staff is appropriate at this time.
Is there a motion?
So,
Second?
second.
Any discussion? All right, again, just a few remarks. I want to particularly thank Congressman Blumenauer, Fitzpatrick, Marino, and McGovern, and Senators Feinstein and Bitter for their public comment on our animal fighting amendment, as well as the many other judges. We heard from lots of judges and stakeholders who also wrote to us, including the ASPCA and its members, the Humane Society, and various other animal welfare organizations. In fact, we received more pieces of public comment, maybe 50,000 letters or so, on this amendment than any other amendment in the history of the Commission. The Commission has heard your concerns, and today we will vote, I think, to significantly increase the penalty for these offenses by increasing the base offense level for this crime from a level 10 to a level 16. This change will result in a 250% increase in the bottom of the applicable guideline range for the typical offender prosecuted for these offenses. This change reflects the recent increase in the statutory maximum penalty from 3 to 5 years and better accounts for the cruelty and violence inherent in animal fighting crimes. We heard testimony about dogs and pictures. We heard testimony, saw pictures about dogs who were being beaten, tortured, and killed. We found further support for this increase from Commission data evidencing a high percentage of above-range sentences in these cases. With today's amendment, average sentences are more likely to be within or near the new sentencing range. The Commission has also revised and expanded the existing departure language to address issues of extreme cruelty and neglect and animal fighting on an exceptional scale. We will now have a vote on the motion. How many vote aye?
Aye.
Any nays? All right, the amendment is adopted unanimously.
The next amendment for your consideration is the Child Pornography Circuit Conflict Amendment, which addresses certain conflicts and application issues that have arisen when applying the guidelines to child pornography offenses. First, the proposed amendment responds to differences among the circuits in cases in which the offense involves infants and toddlers. The applicable guidelines, 2G 2.1 and 2.2, currently include an age enhancement for minors under the age of 12, but these 2 guidelines do not provide a further enhancement for cases in which the victim was unusually young or vulnerable, that is, an infant or a toddler. Courts have differed over whether the vulnerable victim adjustment at 3A 1.1b1 may be applied in such a case. The proposed amendment responds to the circuit conflict by providing higher penalties for cases involving infants and toddlers. It does so by amending an existing enhancement in those guidelines to include infants and toddlers within the scope. Second, the proposed amendment responds to differences among the circuits in applying the tiered enhancements for distribution in 2G 2.2, 2.1, and 3.1. There are two related issues that typically arise in these cases. The first issue is when a participant's use of a peer-to-peer file sharing program or network warrants a minimum two-level enhancement under subsection B3F. The proposed amendment amends that subsection to provide that the two-level enhancement applies if the defendant knowingly engaged in distribution, and an accompanying application note describes what that term means. Similar changes to the two-level distribution enhancements at 2G 2.2b3 and 2G 3.1b1f are also made. The second issue is when, if at all, the use of a peer-to-peer file sharing program or network warrants a 5-level enhancement under B3b. The proposed amendment revises that enhancement and the accompanying commentary to clarify that the enhancement applies if the defendant distributed in exchange for any valuable consideration. The proposed amendment makes parallel changes to 2G 3.1 and the accompanying commentary. A motion to promulgate the proposed amendment with an effective date of November 1st, 2016, and with technical and conforming amendment authority to staff is appropriate at this time.
Thank you. Is there a motion? Second?
Second.
Any discussion? As the Supreme Court recognized in the case Braxton versus the United States, it is the Commission's responsibility to resolve conflicting interpretation of the guidelines by circuit courts, and today we vote to resolve several long-standing circuit conflicts in the area of child pornography. In doing so, we do not intend to either increase or decrease the guideline ranges or sentences for this class of offenses. Rather, the Commission merely intends to simplify several unnecessarily confusing issues that have arisen with great frequency in the context of child pornography guidelines. In doing so, we are acting to make sure that these guidelines relating to the distribution of child pornography will apply if any defendant knowingly distributed, conspired, or willfully caused another person to distribute any sexually explicit material involving a minor. While we believe these specific improvements to the child pornography guidelines are helpful, we recognize that they are limited in scope. We continue to urge Congress to act on the recommendations outlined in the Commission's 2012 report to Congress on federal child pornography offenses so that the Commission can make more comprehensive changes to the guidelines to better reflect the current spectrum of offender culpability and technological changes. All in favor of the amendments?
Aye.
Anyone against? All right, unanimously carries.
The final amendment for your consideration is the immigration amendment. This two-part proposed amendment is a result of the Commission's multi-year study of the guidelines applicable to immigration offenses. Part A revises the alien smuggling guideline at 2L1.1. The proposed amendment amends an existing enhancement at B4 by making it offense-based rather than defendant-based. Second, it provides that an unaccompanied minor is a minor unaccompanied by a parent, adult relative, or legal guardian. Third, it revises the definition of minor to include individuals under the age of 18. And finally, it raises the enhancement from 2 levels to 4 levels. The proposed amendment also addresses offense in which an alien, whether or not a minor, is sexually abused. To ensure that the existing serious bodily injury enhancement of 4 levels will apply in such case, the amendment amends the commentary to 2L1.1 to clarify that the term serious bodily injury includes conduct constituting criminal sexual abuse. Part B of the proposed amendment amends 2L1.2 to eliminate the use of the categorical approach for predicate felonies in that guideline. First, the proposed amendment provides a subsection B1, a new tiered enhancement based on prior convictions for illegal reentry offenses. Second, the proposed amendment changes how 2L1.2 accounts for pre-deportation convictions, basing them not on the type of offense but on the length of the sentence imposed for a felony conviction. The proposed amendment incorporates these new enhancements in subsections A through D at B2. Third, to account for post-reentry criminal activity, The proposed amendment inserts a new subsection B3 to provide a tiered enhancement for a defendant who engaged in criminal conduct resulting in a conviction for one or more offenses after the defendant was ordered deported or ordered removed from the United States for the first time. Finally, the proposed amendment makes several changes to the commentary, including a revised departure provision reflecting these structural changes. A motion to promulgate the proposed amendment with an effective date of November 1st, 2016, and technical and conforming amendment authority to staff is appropriate at this time.
Is there a motion?
So moved.
Is there a second? Second. Any discussion?
I'd like to speak to the proposed amendment to 2L 1.2. I support this amendment because it dramatically simplifies the application of a guideline that currently applies in nearly a quarter of the federal cases that are prosecuted each year. And it does so in a manner that I believe will lead to more proportional punishment for illegal reentrants. Every single year since I joined the Commission in 2006, the Supreme Court has heard one or more cases involving the categorical approach, which applies to 2L 1.2, the illegal reentry guideline. As 4 appellate judges explained in a recent case involving the categorical approach in a different context, almost every term the Supreme Court issues a new decision with slightly different language that forces federal judges, litigants, and lawyers and probation officers to hit the reset button once again. In the view of these judges, a better mousetrap is long overdue, one that uses a more objective standard, such as the length of the underlying sentence. This is exactly what this proposed amendment does. It abandons the categorical approach in favor of a simpler model that bases key enhancements on the length of sentence rather than on the nature of the offense. Case after case, as well as the testimony of numerous stakeholders who have appeared before the Commission in the past 10+ years, demonstrate that the difficulty in applying the categorical approach to state statutes that vary tremendously across jurisdictions. Not only does this process raise complex legal issues, it requires probation officers and litigants to track down dated state criminal records, often without success. The changes we propose to 2L 1.2 today will simplify the work of federal courts, probation officers, and litigants, and ensure that additional aggravating factors such as recent criminal conduct and previous illegal reentries are taken into account in calculating an offender's offense level. These additions, as well as mitigating aspects of the proposed amendment, will better account for the culpability of individual offenders. While there is little doubt that in some cases the newly structured enhancements in this proposed amendment will over or understate the seriousness of the defendant's prior criminal conduct, the proposed amendment's revised departure language grants judges explicit authority to depart upward and downward as warranted by the facts underlying the offender's prior criminal record. In closing, I note that this proposed amendment is supported by, among others, the vast majority of border judges who provided testimony to the Commission, the Department of Justice, the Practitioners Advisory Group, and the Probation Officers Advisory Group.
Thank you.
I just want to say a brief word about the alien smuggling amendment that we have before us. The department had asked us to increase the base offense level for this, which is a request for an across-the-board increase in all cases, based on the department's view that alien smuggling cases are increasingly dangerous and tied to criminal organizations. We looked very carefully at this issue, but our data did not justify an across-the-board increase. Critically, the department itself seeks a sentence below our current base offense level in a full 37.2% of all cases as part of its fast-track disposition program, which undercuts the view that all the cases are as serious as the department claims. We also found that the majority of the defendants convicted of this offense serve low-level functions in the smuggling operation. So it would be inappropriate to raise the base offense level in the face of this data. Instead, the proper course is to address the cases of higher risk highlighted by the department with special offense characteristics, which is what the guidelines do. If the offense involved the intentional or reckless creation of a substantial risk of death or serious bodily injury to another person, the offense level goes to 18. So the guidelines already address this issue and do so at an even higher level than the level 16 requested by the department. If someone is actually seriously injured during an alien smuggling offense, 4 additional levels are added. If the injury is permanent or life-threatening, 6 levels are added. If death results, there's a 10-level increase. If a dangerous weapon is possessed, the offense level would go to level 18. In addition, today we address the increasing incidence of cases involving unaccompanied minors by increasing that special offense characteristic, or I believe we will address it, from a 2-level increase to a 4-level increase. So what the guidelines do in this context is link an offender's offense level with his or her culpability. If the offense creates a risk to human life or causes injury, the guidelines already account for that, as they should. But it makes no sense to change the base offense level for everyone on this record when the cases themselves are not uniform, which is what our record and DOJ's own practice reflects.
Thank you. Ms. Morales, I think now's the time.
Are we done? Overall, so I did want to comment, but across the board, a little summary statement. Thank you, Chair Saris. On behalf of the Attorney General, I really want to thank the Commission for all the hard work you did this amendment cycle as we work together to improve the federal sentencing guidelines. And on a more personal note, I want to thank the Commission, the Commissioners and the staff for welcoming me in the middle of this process. It's been a huge honor and a privilege, so thanks. DOJ is grateful for the Commission for eliminating, as we just talked about, the so-called bedeviled categorical approach from the illegal reentry guideline. Of course, it was an approach that was resulting in vastly divergent results in cases across the country, and which, given its complexity, sought too many prosecutorial as well as, of course, judicial resources. And although this isn't a perfect solution, and we don't think there is a perfect solution, the Commission's action today will have an immediate and substantial positive impact. We particularly appreciate the Commission's efforts to amend the guideline to better address the court's recent criminal conduct, not just pre-deportation conduct, and to better account for multiple previous convictions. But we are, however, indeed frustrated that the Commission didn't raise penalties for alien smuggling offenses across the board. We believe that the current penalties do not properly reflect the seriousness of the offense, simply. An offense that, as Director of U.S. Immigration and Customs Enforcement, Sara Saldaña, noted in her letter to the Commission, exposes migrants to a wide variety of dangers at every stage of the process, regardless of the defendants that we have in front of us, and results in countless sexual assaults, injuries, and deaths, most of which are not accounted for in the enhancements. On the other hand, we do thank the Commission for increasing the enhancement for smuggling minors and for expanding the scope of the enhancement to include victims under the age of 18. And the Department will indeed try to leverage these and other applicable enhancements to get sentences that correlate more closely with the seriousness of this offense. We also want to thank the Commission for raising the penalties for animal fighting. As Deputy Assistant Attorney General Jean Williams noted in her testimony, trends point to an increase in both unlawful animal fighting activity and federal law enforcement response to it. And the Department of Justice is working to reverse this trend, and the increased guidelines will really serve as a useful tool in combating this offense. Regarding the child pornography offenses, we supported the Commission's decision to add a mens rea element to address the circuit conflict. And although the language does not track the language that we recommended, we are encouraged that the Commission clarified that the enhancement for distribution will apply to those who engage in a conspiracy to distribute, and that it will specifically reference distribution in exchange for valuable consideration, and that the sexual abuse of infants and toddlers is specifically referenced. These victims are the most vulnerable, and defendants purposefully target them because they're the least able to communicate their victimization. Regarding the compassionate release, the BOP engages in a rigorous analysis of the defendant's circumstances to include the nature of the underlying offense, public safety concerns, victims' comments, and institutional adjustments, among many other factors, before determining whether filing a motion pursuant to its statutory authority. That said, the Department is re-examining the policies to determine whether and to what extent changes to the current reduction in sentence policies are necessary and advisable. So we were disappointed that the Commission chose not to work more closely with us in developing guidelines so that all the criteria could be more closely aligned. And we are particularly concerned that the Commission's new criteria is too broad and too vague and will seem to make eligible inmates that, in our view, should not benefit from early release. Finally, we thank the Commission for deciding to give the issue of Social Security fraud a thorough review in the next amendment cycle.
Why don't we wait on that particular comment?
We'll talk about that later.
Yeah.
But all I was going to say, I look forward to working with you on that and other issues next year.
Yes, do you want to jump in?
Yeah, I thank you, Chair. I thought that I wouldn't say anything, but of course, I think I'm compelled to address the issue of compassionate release in the context in which it was presented to us. I agree with the with Department of Justice that the Bureau of Prisons has its own set of considerations, but the statute empowers and directs the Commission to set forward a set of criteria that judges can follow in exercising their judgment. Normally, one would not say that this commission would have to address a set of guidelines or criteria different from Bureau of Prisons. But the reality is that the Bureau of Prisons has not, in the past, rigorously analyzed these petitions. All one has to do is look at the Inspector General's report, a third party, looking at the practices of the Bureau of Prisons to conclude, as only one can, that the Bureau of Prisons has not been vigorous in carrying out the congressional directive with respect to compassionate release. And because of that inactivity, and because the Commission believes there is a responsibility to carry out congressional directive, the Commission looked at that criteria and developed its own set of criteria. Now, it may be that there are differences between the criteria that the Commission has set out and the Bureau of Prisons, but that's not really the problem. The real problem is that the Bureau of Prisons was not responsive to this congressional directive. As the chair pointed out in her opening remarks, numerous prisoners simply died pending the consideration by the Bureau of Prisons of the request for compassionate release. And so it was the inactivity, at least in this commissioner's view, it was the inactivity that prompted us to try to respond to a concern that a number of witnesses brought forward to us during the hearing. I am delighted that the Bureau of Prisons and the Department of Justice says we should work together. I think we should work together. But working together is not a substitute for inaction. And therefore, I think that this Commission's role in establishing a set of criteria demonstrates the urgency and the necessity of the Bureau of Prisons to respond to congressional directive. We are responding, and we trust that the Bureau of Prisons will do so as well. Thank you.
I'm going to pivot back for a minute to immigration and talk about the guideline we're about to vote on. Today, the Commission will also vote on whether to promulgate a set of amendments to the guidelines for the two most common immigration offenses, alien smuggling under Section 2L1.1 and illegal reentry under Section 2L1.2. In recent years, immigration offenses have been either the most common federal offense type or close to second to drug offenses. Approximately 18,000 federal offenders were sentenced under just these two immigration guidelines in fiscal year 2015. I want to address the amendments to the two immigration guidelines separately. Let me start with alien smuggling. Back in the fall of 2014, former Deputy Attorney General James Cole wrote to the Commission stating that the Department of Justice considered guideline penalties to be inadequate for alien smuggling offenders, particularly those offenders who smuggle unaccompanied minors. He observed that unaccompanied minors are the most vulnerable of all persons being smuggled, and that they are sometimes subject to unspeakable abuses, including sexual abuse. In recent years, our country has experienced an unprecedented migration of children from Central America. More than 100,000 children have come alone in the last 2 years, far outpacing previous years and seriously straining the U.S. system designed to provide care and custody for those particularly vulnerable refugees. Beginning in the fall of 2011 and every year forward, the numbers of children arriving at the border doubled until the height of the crisis in 2014, when more than 68,000 unaccompanied children were apprehended. This represents a nearly tenfold increase from the historical norm of 7,000 to 8,000 children from 2004 to 2011. unaccompanied minors are being smuggled into the United States in record numbers, particularly minors from Central American countries. At the Commission's public hearing in March, we received testimony from expert witnesses that these vulnerable minors are often subject to abuse, sexual and otherwise, during the course of smuggling offenses. The amendment addresses the smuggling of unaccompanied minors in two important ways. First, it will increase the enhancement for smuggling unaccompanied minors from a 2-level increase to a 4-level increase. Second, the amendment will clarify that any sexual abuse, not just limited to minors, results in a 4-level increase in smuggling cases. These two changes better reflect the increased culpability of offenders who engage in some of the most serious types of alien smuggling offenses. Now I want to address the proposed amendment to the Illegal Reentry Guideline, 2L 1.2. Based on the Commission's current data, this amendment is particularly important because illegal reentry comprises approximately 22% of the federal caseload concentrated along the southwest border. In April 2015, the Commission issued a report on illegal reentry offenses, which can be found on our website, and I urge you to read it. There are two main points about the proposed amendment that I want to highlight. First, the amendment greatly simplifies the operation of the guideline, which has been the source of a great deal of litigation, uncertainty, and criticism. The proposed amendment does so by abandoning the so-called categorical approach, you've just heard a little bit about that, to determine whether illegal reentry offenders' prior felony convictions warrant an enhancement. Courts and stakeholders for many years have complained that the categorical approach is too complex and resource-intensive. For example, because every state defines its crimes differently and state records are so hard to obtain sometimes, it is often difficult to determine if a crime falls within the definition of a crime of violence. Currently, courts, probation officers, and practitioners devote enormous resources to applying the categorical approach to determine whether prior convictions should receive an enhancement as a crime of violence, drug trafficking, or an aggravated felony. The categorical approach has also proven to be an ineffective way of identifying the most severe offense types for enhancement. So, instead of the categorical approach, the proposed amendment adopts a much simpler sentence-imposed model for determining the applicability of predicate convictions. In other words, the level of sentencing enhancement will be determined by the length of the sentence imposed by the sentencing judge. We think this change is appropriate because the length of sentence imposed by a sentencing judge is a good indicator of how serious the court viewed the offense at the time. This significant change also avoids all the complications of the categorical approach. The vast majority, not all, but the vast majority of the witnesses at our March hearing favored the sentence-imposed model. We received support for this approach from 4 of the 5 districts with the highest illegal reentry caseload. In addition, the Department of Justice and 2 of the Commission's advisory groups, the Probation Officers Advisory Group, which we call POAG, and the Practitioners Advisory Group, which we call PAG, supported the proposed amendment. Witnesses for both the advisory groups testified that the sentence-imposed model would be much easier to apply than the categorical approach and would result in savings of judicial resources at both the trial court and appellate levels. Some witnesses suggest that the sentence-imposed model can be problematic because different counties punish crimes differently, particularly if a judge thinks that a defendant is about to be deported. The Commission has addressed those concerns by clarifying that a departure is available in cases where the sentence imposed either overstates or understates the seriousness of the prior offense. I would like to recognize that the Commission also did receive a great deal of public comment in favor of a sentence served model. In other words, what amount of time did the defendant actually serve? While we reviewed and considered these views carefully and seriously, ultimately this approach is not feasible given the limits of state record keeping. The sentence-imposed approach is also consistent with how the guidelines score criminal history generally. The second point I would make is that the proposed amendment accounts for the past criminal conduct of these offenders in a broader and more proportionate manner. Specifically, the amendment addresses concerns raised about the severity of the current 16-level enhancement for prior felonies based solely on a defendant's single most serious conviction prior to his or her first deportation. Depending on the nature of that conviction, an enhancement of as much as 16 levels can occur. Even if an offender's predicate conviction is so old that it does not receive criminal history points under the guidelines, a defendant still can receive as much as a 12-level enhancement. For this reason alone, the Commission has heard repeated complaints about this guideline, particularly these 16 and 12-level enhancements, which apply to nearly one-third of all illegal reentry cases. Our data is consistent with these concerns. Indeed, only 27.4% of defendants who currently receive the plus 16 level enhancement are sentenced within the guideline range. Accordingly, the pending amendment reduces the level of enhancement for a single deportation conviction to a maximum of 10 levels. But at the same time, it also addresses the concern that the existing guideline only captures criminal conduct that occurs prior to the first deportation. In our recent report, we concluded that 48% of illegal reentry offenders in the study sample were convicted of at least one offense after their first deportation, other than prior illegal reentry convictions. In addition, immigrants convicted of illegal reentry have re-entered the country an average of 3.2 times. Yet the current guideline does not account for any criminal conduct that may be committed after the offender illegally re-enters the United States. The proposed amendment adds a new tiered enhancement specifically aimed at criminal conduct occurring after the defendant has re-entered the country illegally. It also adds an enhancement to account for the number of times an offender has been convicted of illegal reentry. I would also point out that the amendment differs from our proposal in January in that it does not increase the base offense level in the illegal reentry guideline. The Commission received a great deal of public comment on this issue, citing statistics in our own report. That report found that 1/2 of those offenders had at least one child living in the United States. These offenders had an average age of 17 at the time of their first entry into the United States, and nearly 3/4 had worked in the United States for more than a year at some point prior to their arrest for the instant offense. Many unlawful immigrants keep returning to work and or to be with their family or out of fear of drug traffickers, not to commit crimes. The Commission was persuaded by the majority of public comment and on its own data that the current base offense level of 8 should remain unchanged. I would note that the Commission is unable to conduct its typical impact analysis, prison impact analysis, for this proposed change because it is impossible to predict how the various fast-track programs, those are the programs which expedite deportation, may be revised after its implementation, and fast-track programs play such a large role in illegal reentry cases, particularly along the southwest border. I can say, however, that the Commission estimates that the average guideline minimum would decrease from 21 to 18 months as a result of the new amendment. This does not mean that the average sentence will decrease, and yet, for the reasons that I've already mentioned, there may be even some sentences that will increase. So, in sum, we believe that the proposed amendment will be easier to apply, will reduce litigation and uncertainty, will mitigate areas of over-severity, and appropriately account for criminal conduct that currently is not reflected in the illegal reentry guideline. So, having said all that, I call for a vote on the motion. All those in favor?
Aye.
Anyone opposed? It carries unanimously. Ms. Grilly.
Yes, Judge. Because the Immigration and Child Pornography Circuit Conflict Amendment may have the effect of reducing the term of imprisonment recommended in the guidelines for certain categories of offenders, is there a motion pursuant to Rule 2.2 of the Commission's Rules of Practice and Procedure to instruct staff to prepare a retroactivity impact analysis?
That fails for lack of a motion, and let me make this comment on retroactivity. The Commission has statutory authority to make any amendment retroactive if it will have the effect of lowering penalties for a category of offenses or offenders. In deciding whether to make an amendment retroactive, the Commission considers several factors, including 1, the purpose of the amendment, 2, the magnitude of the change, and 3, the difficulty of applying the amendment retroactively. First, with respect to immigration. The purpose of that amendment, in great part, was to simplify its operation, reduce litigation and uncertainty, and to more broadly and proportionately account for criminal conduct. The amendment is expected to decrease guideline ranges for some offenders, but increase them for others. Furthermore, it would be extremely difficult to identify offenders who might benefit from retroactivity because the Commission does not routinely collect data about deportation dates or about which prior conviction or the type of prior offense that resulted in an enhancement under the current illegal reentry guideline. Similarly, the purpose of the amendment to the child pornography guidelines was not to effectuate an overall reduction in guideline penalties, although it may have the effect of reducing the guideline range for some offenders. The amendment is intended to simplify guideline application and resolve the litigation surrounding certain aspects of its operation. Like the immigration amendment, we do not routinely collect the information concerning the intent of the distributor necessary to identify and characterize the offenders who might benefit from retroactivity. Ascertaining the overall effect of the amendment would be difficult because that determination depends on data that the Commission does not routinely collect. For these reasons, we've decided against retroactivity. And last, but I would like to comment on a new bill, a new act that passed, the Bipartisan Budget Act of 2015. The act passed in November 2015 after the Commission's amendment cycle had commenced. When new legislation is enacted in the waning days of the calendar year, it is not uncommon for us to delay action and to defer to the following amendment cycle because of the abbreviated time framework in which to work on the issue. In this particular instance, the Commission voted in January to publish a proposed amendment that would provide a guideline reference for the new conspiracy offenses created by that act, but did not publish any specific offense characteristics or other guideline changes to specifically address the increased statutory maximum for certain types of offenders, such as third-party facilitators. The Commission received written comment from members of Congress, the Justice Department, and the Inspector General of the Social Security Administration, suggesting that the change, as initially proposed, does not adequately address the type of cases and offenders covered by the new 10-year statutory maximum penalty. I would like to acknowledge the important work, difficult work, as well as the continued oversight led by the Senate Committee on Finance and the House Ways and Means Committee, as well as the Senate and House Judiciary Committees, to ensure aggressive implementation of these new penalties relating to Social Security fraud. Specifically, I would like to acknowledge a very thoughtful letter we all read from Chairman Goodlatte, Congressman Brady, and Senator Hatch expressing their views on the proposed amendment. The Commission continues to take into consideration this feedback as well as the public comment in support of the specific sentencing enhancements. At this juncture, the Commission is persuaded that this issue merits additional study before making a final policy decision. Accordingly, the Commission has decided to defer action on the Act until the next amendment cycle and to make it a priority for us next year, and we will look forward to working with Congress, the relevant agencies, and the stakeholders as we move forward into the next amendment cycle. I wanted to ask, did you want to say something?
All I wanted to say is that we look forward to working with you on that.
Okay, so there we are.
Jumping the gun.
Anything else anyone wants to say about that? Okay, so a lot of work went into it. I particularly want to thank our excellent staff. I mean, really, our work is based so extensively on the data and the legal analysis and the work of our entire staff. A lot happened this year, and thank you very much to all of you. Is there any further business before the Commission? No? So do I hear a motion to adjourn?
So moved.
Any opposed? Anyone want to stay here all afternoon? It's unanimously carried, and have a lovely weekend to everybody. Thank you.